Welcome to the 51st Ellie Newman Memorial Moot Competition Final. Tonight we are joined by esteemed judges, staff, mooting competitors, students, family members, and persons from the profession. My name is Valine Holness, and I have the privilege of being your Director of Proceedings this evening. Speaking of esteemed judges, little known fact that lawyers and law academics from this university played a very important role in the establishment of the Small Claims Court. The pilots of the Small Claims Court were established, and the law clinics at Pietermaritzburg and in Howard College in Durban assisted applicants in preparing their claims. Professors David McCoy-Mason and Ellie Newman trained the very first group of commissioners for the KwaZulu-Natal province in the Moot Court upstairs in this university. So from small claims courts to big courts, we have our judges and our academics represented. Now, for our promising mootists, they gain valuable experience and training in written and oral advocacy, and the experience they gain also includes legal research, analysis, writing, and oral advocacy skills, which they polish throughout the competition. And they have elbowed their competitors out of the way in getting here. And on that note, congratulations to those in the previous rounds. So our audience, thank you for being here this evening, both in person and online. We are streaming. If I may ask to please switch off your cell phones if you have not yet done so. It is now my honor to introduce Professor Warren Friedman, who's our acting dean and the head of the School of Law, to do our welcome.
Thank you, Professor Holness, for that warm welcome. Good evening, ladies and gentlemen. On behalf of the University of KwaZulu-Natal and the School of Law, it's my honor and privilege to welcome you to this, the 51st Ellie Newman Memorial Court Competition Final. I want to begin by extending a warm welcome to our presiding judges, Justice Zach Yaqub, Advocate Sandhya Mahabir SC, and Professor David McCoy-Mason. As I'm sure you're all aware, our three presiding judges have reached the very heights of the legal profession. Justice Yaqub is a retired Justice of the Constitutional Court. Advocate Mahabir is chairperson of the KwaZulu-Natal Society for Advocates. And Professor McCoy-Mason is an emeritus professor and former dean of this law school. While we cannot claim credit for all of their achievements, I note with great pride that all three of our presiding judges graduated from this law school. The presence of our presiding judges here tonight adds immeasurably to the prestige of this event and strengthens the ties between the law school, the judiciary, and the legal profession. I have no doubt that it will also provide our Moot finalists with a much more rewarding learning experience than would otherwise have been the case. Apart from our presiding judges, I also want to extend a warm welcome to Dr. Mark Hay, the Deputy Chair of the Council of the University of KwaZulu-Natal, and Mr. Sponelo Mtembu, the chairperson, the newly elected chairperson of the Howard College Students' Representative Council, as well as the other members of the Students' Representative Council. We are grateful that you could join us for this special event. I also want to welcome the sponsors of the prizes tonight, Juta & Company and LexisNexis, my colleagues in the School of Law, our students and their families, friends of the University of KwaZulu-Natal, and all of our other distinguished guests. This event would not be possible without your support. The Moot Court Final is one of the highlights of the School of Law's annual academic program. And that's because it provides us with an opportunity to celebrate the hard work of our final year LLB students and the work they've put into this Moot Court program. In addition, it also provides our Moot finalists with an opportunity to demonstrate their advocacy skills that they've developed over the course of their studies. Now, apart from providing our Moot finalists with an opportunity to demonstrate their advocacy skills, the Moot Court Final also provides the School of Law itself with an opportunity to highlight and promote those areas of the law in which the school has established a reputation for excellence, from both a teaching and research perspective. As the topic of tonight's Moot final indicates, one of the areas in which the school excels is bioethical and health law. Besides publishing cutting-edge research in this field, the school has also introduced an exciting and innovative coursework, Master of Laws program in health law, and we're going to hear a bit more about this program shortly from the program head, Professor Donrich Theldar. However, I would urge anyone who's interested in this exciting area of the law to consider joining our health law LLM program. I also want to take this opportunity to thank all those members of the academic staff who sat as judges in the preliminary rounds of the Moot Court competition. In addition, I'd like to express a special thank you to Mr. Matthew Kimball and the other members of the Moot Competition Advisory Committee, as well as Ms. Hazel Langer and the other members of the College Public Relations Department for organizing tonight's event. Organizing the Moot Court final is an onerous and time-consuming undertaking. It requires the members of the committee to plan and implement an astounding number of tasks, and I've been particularly impressed with their attention to detail. No single task, no matter how minor, has slipped through the cracks. I think they've done a magnificent job. Finally, I just want to congratulate our Moot finalists, Ms. Tanatswa Chinyanga, Ms. Chloe Lead, Ms. Sibahle Zondi, and Ms. Lumka Swana. The fact that we have a woman-only finalists tonight is also a timely reminder of the fact that this is the centenary of the Women Legal Practitioners Act of 1923. As its title suggests, this act allowed women to be admitted into legal practice as attorneys and advocates for the first time in South Africa. So tonight's Moot Court final forms part of the School of Law's celebration of the enormous contribution that women have made to the development and transformation of the law in South Africa over the past 100 years. And lastly, I want to wish all four finalists the very best with their arguments tonight. We're very proud of what you've accomplished. Thank you very much.
It gives me great pleasure now to welcome you to view the video from Professor Donrich Theldar on the topic that is being engaged on by the finalists today from the Health Law Program. Thank you.
Greetings everyone, I am Donrich Theldar. Microscopic cells are not frequently thought about, but not understanding the ownership and consent rights associated with microscopic cells can have profoundly negative consequences. The case that will be argued before the Moot Court this evening is roughly based on a real case, namely that of Henrietta Lacks. Let me quickly tell you her story. In early 1951, Henrietta Lacks, a 30-year-old woman, was diagnosed with cancer. She underwent treatment at Johns Hopkins Hospital in the United States. Sadly, however, despite her treatment, Henrietta died of cancer in October 1951 and was buried in an unmarked grave. Earlier in 1951, a tissue sample had been retrieved from Henrietta at the hospital. It was sent to a research laboratory of cell biologist Dr. George Gay, where the cancer cells from the sample was isolated. These cells were different from all previous cells studied in Gay's laboratory. By applying a special technique, they could grow and divide indefinitely in a culture medium. Using these cancer cells, Dr. Gay had developed the world's first immortal human cell line, meaning that the cells could grow and divide indefinitely. He called it the HeLa cell line after Henrietta Lacks. Over more than 70 years, the HeLa cell line has been used in countless medical breakthroughs worldwide, ranging from developing the polio vaccine in the 1950s to studying cancer and the human genome, and more recently, developing COVID-19 vaccines. Almost 11,000 patents are involved in the HeLa saline. All of this with eye-watering financial implications. Furthermore, more than 110,000 scientific articles have been published about research done on the HeLa saline. The big problem, however, is that Henrietta Lax's consent to use her cells for research purposes was never obtained. Her privacy was violated, and neither she nor her descendants benefit financially or in any other way from the commercial use of her saline. Although such actions were acceptable practice in the 1950s, society's values have changed, and the HeLa saline is now controversial. Several ethical and legal issues are important. One such issue is the ownership of the HeLa saline. Turning now to contemporary South Africa, how can we be sure that a similar violation of privacy and ownership rights will not occur as a result of the actions of potentially unscrupulous researchers? In what circumstances do we own our tissue and resulting salines? And how are we protected in the case of willful legal non-compliance? I trust that our moot court advocates will explore these questions, and I trust that we will have a very interesting and invigorating evening.
It now gives me pleasure to hand over to our registrar for the evening, who is Mr. Azande Cele.
Rise in court.
Thank you very much for working the late hours of the evening. Yeah, thank you very much, Mr. Registrar, for working late into the evening. This court doesn't pay overtime, but well, never mind, but we hand over the proceedings to you. Thank you very much.
The Moot Court of the University of KwaZulu-Natal is now in session. May it please the court, whereas it is deemed necessary and expedient that for the better administration of justice, a court of supreme jurisdiction be constituted. And whereas the University of KwaZulu-Natal at Durban, by reason of the profusion of legal talent that lurks within its territorial boundaries, is deemed to be most appropriate forum for the exercise of such jurisdiction. And whereas it is essential for such forum to dispense justice unencumbered by such legal technicalities as, inter alia, the audi altrum partem rule, now, therefore, these present witnesseth that it is hereby proclaimed that the moot court of the said university shall exercise such supreme jurisdiction. And it is so exercising its jurisdiction that the moot court shall not be bound by precedent emanating from any other tribunals, which tribunals are hereby declared to be tribunals of jurisdiction inferior to that of the aforesaid moot court. And whereas it is necessary for the said moot court to be convened for the dispatch of urgent business, more particularly the correction of precedents originating in the aforesaid inferior tribunals, I now accordingly declare the 51st session of the said moot court duly opened.
Thank you, Mr. Registrar. Thank you, Mr. Registrar. Our counsel here?
They are present, yes, sir.
Right, so we thought about the case, and I thought that it may be right for the counsel for the appellant to begin. So who's leading the argument? Please introduce yourself and your colleague and proceed with the argument. Is someone going to read the facts first, Mr. Registrar?
As it pleases the court,
Right.
may I call the first case? In the matter between the University of Mpangeni and Andile Langa. The University is a Mpangeni is a world-renowned public university. It operates a training clinic on the outskirts of Mpangeni, where it provides free healthcare services to the local community and trains its students in various health professions. Ms. Hlengiwe Langa visits the clinic and complains about a tumor on one of the health practitioners suggests that a biopsy sample of the tumor should be taken to be tested for cancer. After Ms. Langa signs a consent form that allows the University of Mpangeni to analyze the sample for diagnostic purposes and to subsequently use such sample and data generated for academic and commercial research, the health practitioner takes the biopsy sample of the tumor to have it tested. Sadly, the biopsy test results come back with bad news. Ms. Langa is diagnosed with late-stage cancer. Despite receiving all the treatment available, Ms. Langa passed away a year later. Researchers at the University of Mpangeni continue to conduct research on the biopsy sample from Ms. Langa. They create a cell line from the biopsy sample that proves to have properties particularly useful in research and call it the Hlela cell line. Given the international demand for the Hlela cell line, the University of Mpangeni starts a laboratory that is dedicated to producing the Hlela cell line and sells the cell line to local and international clients. In the process, the University of Mpangeni earns massive profits. However, some years after Ms. Langa's death, her adult child, Mr. Andile Langa, discovers that the Hlela cell line from which the University of Mpangeni is making money is in fact derived from his deceased mother's body. He instituted an action in the Durban High Court and was successfully awarded all the profits the University of Mpangeni made from the Hlela cell line. The University of Mpangeni appealed to the Moot Court.
Thank you very much. Now, our counsel ready?
May it please the court, I'm Sbahle Zondi and I appear on behalf of the appellant.
Right. Who is with you?
May it please the court, I'm Chloe Lead and I'm appearing on behalf of the appellant.
Respondent?
May it please the court, I'm Tanazwa Chinyanga, appearing on behalf of the respondent.
And junior counsel?
May it please the court, my name is Lumka Swana, appearing on behalf of the respondent.
Thank you very much. I think that we will start now. You know that you have 30 minutes. We will allow you some extra time if we think we've been interfering too much. We will try not to, but go ahead. I think we can go ahead with the appellant. Thank you.
May it please the court. Prior to commencing with our argument, I just wish to notify the court that we will take 15 minutes. I will take 15 minutes for my segment of the argument. My learned colleague, Ms. Chloe Lead, will then take 10 minutes of her argument time and then rebut for 5 minutes.
Yeah, 15 minutes each, unless you decide to share your time differently amongst yourselves. But you have 30 minutes altogether, and for a start, we've said 15 minutes each. I think just leave it there. Right, now the watch starts running now.
In the matter before this court, we submit that the quota quo erred in its decision to grant the respondents the profits generated by the appellant from the creation and distribution of the Hlela cell line. Our argument is structured as follows. I will introduce our argument relating to the consent obtained from the deceased by the appellant. I will then follow with our argument in relation to the ownership of both the deceased tissue and the Hlela cell line. Ms. Chloe Lead will then proceed.
Let me ask you a question. You're talking about ownership, but suppose that after conducting the tests, the medical school threw the tissue away because it was useless now. Could you have claimed money for that?
Justice, may I ask you to
Unless you
rephrase
think that there was an obligation to return the tissue to the owner.
Justice, I believe I may have understood your question. May I kindly ask you to rephrase it?
You want the question repeated? Yeah, okay. Let me just repeat the question then quickly and talk a bit more slowly and a bit more clearly yourself. What I'm interested in is you talking about ownership. Now, if the university, if the medical school had done what had to be done with the tissue, and then it was useless to everybody, and they throw it away, would they be liable for any damages because they threw it away without telling the owner, or you think they were obliged to return the tissue to the owner?
Justice, we submit that the appellants would retain ownership of the tissue as it was donated to them. And by means of the donation, the deceased transferred ownership and possession of the
So
tissue.
your case is that you could have thrown it away if you wanted to.
Yes, Justice. The
And the fact
appellants.
that you didn't is because of your good heart. All right.
Yes, Justice.
Carry on.
Ms. Chloe Lead will then proceed with an argument relating to the prohibition of profit sharing in South African law. I wish to refer the court to paragraph 11 of our heads as we commence.
Sorry, you're eating up your words, so we can't hear you properly.
Is it clear now? Okay, thank you, Justice.
Speak deliberately and carefully. Thank you.
Section 55 of the National Health Act places the requirement that prior to the removal of the tissue from the body of a living person, the written consent of such living person must be obtained by a research institution prior to the removal. In addition, the regulations relating to human participants require that the consent obtained from a research participant must be informed by virtue of the fact that the human participant must be informed about the object, the nature, and the scope of the research which they are to partake in. In light of this, we submit that the consent obtained by the appellants from the deceased was informed, as she was informed about the nature and the scope of the purpose of the removal of her tissue, that being for diagnostic purposes, for purposes of academic research, and for purposes of commercial research. We further submit that the deceased's consent is broad in that it allowed the university to use her tissue not only to diagnose her, but also for unspecified academic and commercial research.
Ms. Zondi, can I interrupt you? You say that the consent was broad. Was it not vague?
Justice, we submit that the consent was broad because at the time of the donation of the deceased tissue, the properties of the tissue were unknown. The properties I refer to are the fact that the deceased tissue, once studied, the tissue was found to be capable of regenerating and forming new cells. And by virtue of that, at the time of the donation, the appellants had no knowledge of this. And so the consent obtained from the deceased was broad.
Deliberately broad?
Deliberately broad, as at the time there was no knowledge from the appellant that they would in fact develop a cell line using the deceased tissue. It could have been for a broader context of the research. And this, we support our submission using the Department of Health guidelines, which we have cited in paragraph 16 of our heads. The guidelines define broad consent as follows. It is the form of consent in which a donor permits the use of the specimen for current research, for storage, and for possible future research purposes, even though the precise nature of future research may be unclear at present. And Justices, we submit that in light of this definition, which is derived from the guidelines, the nature of the deceased tissue was unknown at present, and the guidelines justify the appellant's storage and future usage of the deceased tissue.
Was that a proper informed consent if she didn't know that they were going to make a profit out of that?
Justice, we submit that it is in fact informed consent, as by virtue of signing the consent form, or rather giving the consent form to the deceased, the appellant, may I rephrase my statement, Justice? By giving the deceased the consent form had included the purpose of the research, that being for diagnostic purposes, for academic, and for commercial research. And by virtue of informing the deceased of the purposes for which her tissue would be used, we submit that the consent was broad.
Did it comply? Sorry. Did it comply with the National Health Act's requirements for an informed consent, which says they have to know about the benefits, the costs, and consequences of anything?
Justice, we submit that in light of Ms. Chloe Lead will take the segment relating to costs. However, we do submit that the provisions of the National Health Act were complied with, more especially with focus on Section 55A of the Act. We refer to the case of, Justices, may it please the Court, we seek the Court's permission to admit a case to support our argument in favor of the fact that the deceased consent was informed.
Yes, proceed.
We wish to refer the Court to the case of Castell versus de Greef, in which the Court introduced the principle of informed consent into South African law. In light of Sections 6, 7, and 8 of the National Health Act, respectively, we submit that in this case, firstly, the deceased was given full knowledge of the purpose of the removal of her tissue in terms of Section 55 of the Act. Further,
Ms. Zondi, sorry, I must interrupt you there. Was she given full knowledge of the purpose? Because was she not there for treatment of a tumor, and she was told that she required a biopsy? Was it not reasonable for her to assume that the purpose the tissue was being removed was for that biopsy to be undertaken?
Add to that, with my colleague's permission. Let me add to that, with my colleague's permission, and say, but you yourself say in your argument that you didn't know what possibly the results would be in the end, and therefore you couldn't expressly ask for her consent. If I read that right, if you didn't know as a university, how would she know?
Justice, I concede with the fact that the specific, or rather the precise nature of the purpose of the use of her tissue for research purposes was unclear at that moment of the donation. However, by virtue of the consent form, the appellants complied with the Department of Health ethics guidelines, which require that the consent drawn from a research participant must be broad enough to allow for the future use of the deceased tissue after the donation.
Future use means future making of millions.
There is no specified time in the Department of Health guidelines. However, we submit that because the appellants satisfy the requirement that they disclosed the purpose of the use of the tissue in future, that being for the purposes of academic and commercial research in the broad sense, we submit that the deceased consent is broad.
Okay, can I just check with you? You keep referring to the ethics guidelines of the Department of Health, is that correct? You're relying on the ethics guidelines?
Yes, Justice.
And what are guidelines? How do they weigh up against the National Health Act, which is an act? What strength do these guidelines have if you look at the act itself, the National Health Act?
Justice, we submit that the Department of Health guidelines are set as a support structure to the National Health Act. However, we submit that the requirement of consent, or rather the fact that broad consent is defined in the guidelines, it supports the requirement of informed consent in terms of the National Health Act. So whereas the National Health Act does not specify the form of consent that is sufficient to be obtained by a health establishment rather, from the donor, the guidelines then go further to provide for multiple forms of consent, one of which broad consent is listed in the guidelines. Justices, I wish to refer the courts to paragraph 19 of our heads as I commence with our argument relating to ownership of the cell line. At common law, the Roman Dutch principle, or maxim rather, directly translated to English, dictates that no one is deemed as the owner of his or her own limbs. However, with the shifts in medical law and scientific research, we submit that human biological material has become useful, valuable, independent, and capable of human control. Most importantly, unlike in Roman times, Justices, we submit that human tissue presently carries much value. Drawing from the fact that human biological material is capable or susceptible to ownership, in light of the National Health Act, Chapter 8 throughout prescribes donations as the main means of acquiring ownership over human biological material. We submit that by virtue of the deceased donating or consenting to the removal of her tissue for purposes of diagnosis and further for academic and commercial research, the appellants acquired full ownership of the deceased tissue. The National Health Act is further supported by Regulation 4 of the General Control Regulations, which provides that universities are capable of receiving tissue donated by donors. Furthermore, Regulation 26 of the General Control Regulations prescribes that any institution that acquires tissue from a donor acquires exclusive rights in such tissues. In light of these regulations, read in terms of the National Health... Yes,
what was that authority again?
The General Control Regulations, which we have cited in paragraph 28 of our heads of argument.
Thank you.
In light of the provisions of these regulations, we submit that the appellants are the rightful owners of the deceased tissue and the cell line created thereafter.
Ms. Ondi, can I just return to those regulations? They stipulate that tissue may be donated specifically to a university. But again, we go back to the purpose of Mrs. Langa's visit to the clinic. Wasn't it that she was there for treatment?
Justice, we agree that the primary purpose of Ms. Langa's visit to the appellant's institution is that she sought a diagnosis for the tumor in her body. However, in the consent form, the appellants also included a clause to which they sought the deceased's consent for the use of her tissue for research purposes. It was not obtaining the deceased's consent for the use of her tissue for research purposes was not the primary purpose. However, by removing the tissue from her body, they sought her consent for that and thereafter for research purposes.
Sorry, is
Yes,
your
Justice.
contention then research purposes means you can go beyond research purposes and actually then start making profits as well?
Justice, we submit that by virtue of the fact that the deceased's consent was obtained, the appellants became the owners of the tissue and thereafter the cell line created. However, Ms. Chloe Lead will lead the court through an argument relating to profit sharing and the issue of profits. We do submit, though, that in light of the statutory position stated in the National Health Act,
But
profit
you could
sharing
have done
is...
nothing without the tissue, could you?
Justices, we raise an alternative argument should this court find that our argument relating to the ownership of the deceased tissue and the cell line is defective, resulting from the consent. We raise an alternative argument based on the common law principle of specificatio. This principle is supported by a case, that being the case of Aldine versus Timber Company, in which the court held that the work done on another's material to produce a new object vests ownership in the maker of the new object, as the thing then cannot be reverted to its original form. There must be, in terms of the Aldine judgment, there must be a bona fide creation of a new object using the material of the old object, and that the new object must be of value, and that workmanship or skill must be put into the creation of the new object.
Ms. Zondi, is that
Yes,
not an
Justice.
opportunistic alternative argument?
Justice, may I respectfully ask you to elaborate on your question?
You remove the cells from a patient who is suffering from cancer. You then use it for research and alter it. And then you claim as an alternative, as far as ownership is concerned, because you've altered it, it now belongs to you. Is that not opportunistic?
Justice, we believe that in light of the fact that we firmly believe that we have proven, rather, and submitted that the deceased consent was obtained legally and in line with the National Health Act, the ownership of the tissue vests with the appellant, and in the event that the appellant's consent, the deceased consent is defective, we support our argument in relation to the ownership of the Hlela cell line to vest with the appellants in light of the specificatio principle.
Ms. Zondi, because of the number of interruptions you've been confronted with, we're prepared to allow you an extra 5 minutes.
Thank you, Justice. In light of our argument relating to the common law principle of specificatio, Justices, we submit that in the alternative, and if this court finds that the consent obtained from the deceased is defective, that the appellants are the bona fide possessors of the tissue, but the owners of the cell line by means of specificatio. I now wish to make reference to the material transfer agreement, which requires at clause 3.3, which states rather at clause 3.3 that institutions are merely possessors of human biological material which is donated to them, and that donors remain the owners of such material. We decline this view and accept the view held by legal authors Professor Thalda and Dr. Shozi by stating that clause 3.3 is invalid insofar as it contradicts the National Health Act. The National Health Act states that a donation is the main means of acquiring ownership of human biological material, whereas the MTA provides that ownership vests in the donor and possession is only transferred to the institution. In light of the fact that the MTA clashes or does not comply with the National Health Act, we submit that the National Health Act, read together with Regulation 26 of the General Control Regulations, remains the legal principle or position. Justices, I have reached the end of my segment of the argument. Shall I be of any further indulgence to the court?
Thank you, Ms. Ondi.
Thank you, Justice.
I think my colleagues say 10 minutes more.
15, no, she's reserved for the colleagues.
All right, let your colleagues, but one of the things you need to bear in mind is, I hope that you're going to say that our Constitution does have something to do with all this.
We, in fact, will, Justice.
All right.
Thank you.
May it please the Court, I shall now resume with our submission relating to the prohibition on benefit sharing. I will then move on to the submission relating to the non-applicability of the Protection of Personal Information Act, hereafter referred to as POPIA. The crux of this case relates to the altruistic paradigm underlying health research in South Africa. There is a clear prohibition on benefit sharing in South African legislation. This is stated in Section 60, subsection 4 of the National Health Act. The Act goes beyond a prohibition and criminalizes benefit sharing with research participants and donors. We recognize that human biological material is invaluable to human genomic health research at an international scale. However, should there be benefit sharing, this would result in undue enticement, which would compromise the giving of voluntary, informed consent. In respect to this, there is a lack of case law in South Africa, so we request the Court's permission to draw a comparison and analogy to surrogacy case law in South Africa. May it please the Court, I will refer to surrogacy cases which provide some insight as to the legislature's rationale for a prohibition on benefit sharing and compensation for the use of the human body. The position with regards to surrogacy is that the surrogate mother cannot be paid for her services. There is a prohibition on commercial surrogacy. The court in Ex parte HPP held that this was to protect the public interest and prevent the abuse of vulnerable persons.
But doesn't that prohibition relate to the fact that you can't make a deal beforehand? Because if you make a deal beforehand, then everybody starts making deals and acquiring tissue and so on, and the buying or selling of tissue is not good. I understand that. But if it happens that money is made, and the university says it has a moral obligation to pay, will they be criminally liable?
Justice Yaqub, we submit that they would be. The sections 60, subsection 4 and subsection 5 are very clear that any form of benefit sharing, not just monetary, would put both parties in a position where they could be prosecuted criminally. We submit that the law is very clear on this, as it seeks to protect vulnerable persons from being exploited for their contributions.
And did the High Court ignore these provisions?
Yes, Justice Yakub, that is our submission, that the appeal should be upheld on the grounds that the High Court did not apply the law as it currently stands.
Unless, of course, it interpreted the prohibition narrowly.
Justice Yakub, we submit that a narrow interpretation would still lead to the finding that it is a prohibition and a crime.
Ms. Lead, I have difficulty with the analogy you're drawing between surrogacy and the facts in this case. Isn't there a distinction here? Because with surrogacy, you're volunteering the use of your body. Here, the patient was afflicted with a disease. She went in for treatment for a tumor. It's very different, is it not?
Yes, Justice Yakub, we admit there is the difficulty with this case is there is a complete lack of case law dealing with human biological material. Therefore, we looked to the closest thing we could find in this area of the law, which relates to essentially how the law views the use of the human body, and the fact that the legislature has clearly sought to protect the sanctity of human body parts, whether it be in the form of a donation or in the case of surrogacy, as it were, commonly referred to as rent a womb. May it please the Court, I will then refer to Ex parte WH, another surrogacy case, providing an analogy that we can link to the matter before the Court. In paragraph 64 of that case, the Court held, particularly in countries such as ours, with deep socio-economic disparities and the prevalence of poverty, that the possibility of abuse of underprivileged women is a real and ever-present danger. We therefore submit that the legislature has shown a very clear position on the use of the human body, particularly in South Africa, where should benefit sharing become a thing and a means of earning money by donating parts of your body, this would inevitably lead to vulnerable people choosing this as a means of earning, choosing this path as a means of gaining income. Essentially, what that will do to vulnerable categories of persons in South Africa is it opens up huge debates around what the human body is and the value of it. If you can ascribe a value to parts of the human body, surely that undermines the right to dignity and the right to bodily integrity.
Yes, but aren't you...
Why does the debate undermine anything? Isn't it wonderful to open up a debate in this new area?
Aren't your clients actually making money out of human tissue?
Justice McCoy-Mason, our clients make money off of the results of rigorous scientific inquiry and work that has resulted in them deriving a cell line, which could potentially go on to make breakthroughs in the health domain. If we look at the HeLa cell line in the Henrietta Lacks case that was used for AIDS research, for COVID-19, for cancer, for polio vaccines, yes, they are deriving a profit, but in this case, we're dealing with a public research institution, a university, that the profits are not lining people's pockets.
A public research institution which has converted itself into a profit-making exercise.
A profit-making exercise which then turns those profits, Justice Yakub, into the provision of education, into the provision of free health care for the community of Empangeni. This profit is a means to provide more. It's not a means to grow people's bank accounts.
No, but on the facts, we know that they have made enormous profit out of this, out of the deceased cells. And isn't the difference here that the deceased had no idea what her cells could possibly be used for, whereas with surrogacy, you know exactly what your body is being used for.
Justice Mahabir, we accept that I am not submitting that the legal position is the same between surrogacy and donations of human biological material. Our submission is that it provides an insight into the rationale of the legislature around the human body and the use thereof, and avoiding commercializing that, and avoiding ascribing money or profit from how you use or how you give your body parts.
But commodification is exactly what the clinic did here.
Justice Mahabir, we submit that in terms of the Section 16 right to freedom of scientific research, if we put an end to any form of donations or research into human biological material, then that will trump the right to research, to freedom of scientific research. It will effectively deter researchers and research institutions from engaging in this rigorous process of discovery out of fear that they will have to divert all their profits. That is what the Court of Quo found, that all the profits derived from the process of rigorously extracting, isolating cells and turning that into something which is commercial and can be used for health advancements for the benefit of all of society, as the Hiller case demonstrated.
Why didn't you donate the money to the Human Sciences Research Council?
Justice Jacob, we submit that...
Is that prohibited as well?
No, Justice Jacob, that is not our submission, but the fact that the funds were then used for education and to feed back into the clinic and further laboratories for the benefit of society at large.
Is there any evidence of the University Medical Centre's ethics committee decisions on the matter? I suppose they must have had an ethics committee, and if it decided something, what did it decide? Does your institution boast such a thing as an ethics committee?
Justice Jacob, we're not given that detail of facts in the matter, but we would presume that there would be a research ethics committee.
So what is your policy? What is the policy which is ironed out? Is that published?
Justice Jacob, I'm not at liberty to disclose that as it was not presented for us in the facts. But
and is there such a thing as transparency and openness in what the medical school and the research people do?
Yes, Justice Jacob, I would say that...
Give me an example of that.
If we look at the Justice Jacob, I'm hesitant to use more time of the respondents because I'm being prompted that my time's up.
No, we'll give you 5 more minutes.
Okay.
Go ahead.
Thank you, Justice Mahabir. If we look at openness and transparency, it's difficult to provide more on that detail. We see that they've named the cell line, the Hlela cell line, as an acknowledgement of the donor in this case, and we submit that Justice Jacob, I'm afraid I don't think I understood your question relating to transparency and openness.
Maybe I can come in there. Does this debate not continuously